Hello, everyone. I'm Kevin Gosztola. I'm the editor of the Dissenter newsletter, and welcome. Welcome to the show, this weekly show, Dissenter Weekly. If you're a paid subscriber, you're getting this on February 7th, 2025. If you're just someone out there who has stumbled on the show, you're tuning into this, or you're watching the free version, it is Monday, February 10th, 2025. This show is done to support the work at the Dissenter newsletter. You can go to the dissenter.org and become a subscriber if you're not already. There you'll find a resource, regular coverage of whistleblowing, press freedom, and government secrecy stories. The show is new. This is the third episode. And this week we have an interview with Chip Gibbons, the policy director for Defending Rights and Dissent, who will discuss an article that he wrote for the Dissenter on CIA analyst Asif Rahman, who pled guilty to violating the Espionage Act back in January. It was the last Espionage Act conviction under President Joe Biden's administration. It'll be the first sentencing of someone convicted of violating the Espionage Act under President Donald Trump. But we have headlines for you, and let's get right to them. The first headline for this week is that coalition condemns threat to prosecute critics of Musk's DOGE. That's the Department on Government Efficiency, as he has called it. A coalition of journalists, First Amendment, and press freedom organizations, including Defending Rights and Dissent, the Foundation for Individual Rights and Expression, the Freedom of the Press Foundation, and the Society of Professional Journalists, sent a letter to the interim U.S. Attorney for D.C. named Edward R. Martin, Jr. They objected to a letter from Martin where he seemingly threatened to prosecute critics of Elon Musk's Department of Government Efficiency. The day before your letter, the coalition stated, Wired reported about and named 6 young engineers working for DOGE: Akash Baba, Edward Korstein, Luke Ferrator, Gaudier Cole, Killian, Gavin Klieger, and Ethan Sheotron. The experience and qualifications of public employees is of significant interest. Following this news report, a user on X, it's the platform formerly known as Twitter, made a post also naming those employees, and Musk responded with, "You have committed a crime." And then X suspended that user. As an experienced attorney holding such an important public position, the coalition told Martin, "You must be aware that it's not a crime for anyone, whether they're Wired journalists, ex-posters, or otherwise, to identify individuals openly conducting government work that is of the utmost public concern. The Supreme Court, the U.S. Supreme Court, has repeatedly held that the First Amendment protects the right to publish newsworthy information that the publisher lawfully obtains, including names far more sensitive than those of government personnel. Musk and his DOGE staff have acted with extraordinary secrecy, hiding the names of staffers as well as the criteria for downsizing agencies and ending government programs as they go through their marauding of these systems and databases. But on February 6th, a federal judge issued a preliminary injunction against Musk and his DOGE staff that instructed them that the U.S. Treasury Department will not provide access to any payment record or payment system of records maintained by or within the Bureau of the Fiscal Service. That injunction was sought by a separate coalition of federal unions and advocacy groups. We now have a story involving the right to publish, which was upheld in San Francisco. A San Francisco County Court judge ruled that journalist Jack Paulson was well within his First Amendment rights to report on the arrest record for Maury Blackman, who was the CEO of Premise Data, a data collection and analytics service. Blackman was arrested in 2021. San Francisco police sealed that report in 2022, but Paulson was unaware that the report was sealed when he obtained it from a confidential source and then published it on his site, Tech Inquiry, in 2023. According to the San Francisco Chronicle, Blackman accused Polson of violating state law, and City Attorney David Chu instructed Polson to take down the report, which was rejected. So Blackman sued Polson, and the Electronic Frontier Foundation put out a statement on this victory that puts this into important context, puts it into clear context. Under Bartnicki v. Vopper, which is a 2001 Supreme Court case, it's a precedent. The First Amendment protects journalists who report on truthful matters of public concern, even when the information they are reporting on was obtained illegally by someone else. Without it, reporters would face liability when they report on information provided by whistleblowers that companies or the government wants to keep secret. Those principles were upheld here, although courts have the power to seal records in appropriate cases. If and when someone provides a copy of a sealed record to a reporter, the reporter should not be forced to ignore the newsworthy information in that record. Instead, they should be allowed to do what journalists do, which is report the news. At least if they're worth anything, that's what they do. So that's from the Electronic Frontier Foundation. The next headline is a development in a case involving Purdue Farms whistleblowers. We've loosely followed this over at the Dissenter over the past several years. In January, U.S. District Judge Terrence Boyle ruled that the poultry manufacturer Purdue could not block the U.S. Department of Labor from hearing whistleblower complaints. As the Dissenter covered in August 2024, Purdue sued the Labor Department and asserted that the administrative process for reviewing whistleblower complaints was unconstitutional. That's the process inside of the Labor Department for hearing whistleblower complaints. This case involves two complaints, one from a whistleblower named Craig Watts, a chicken farmer who blew the whistle in 2014 on alleged poor conditions that increased the, quote, chicken's risk of contamination or infection with salmonella, E. coli, and other bacteria, thereby rendering them a threat to consumers who purchase and eat them, end quote. The second complaint comes from whistleblower Rudy Howell, who was allegedly terminated in 2020 after he exposed animal abuse and poor sanitation to the media and public. A lawsuit aiming to block Trump's plan to reclassify workers and replace them. We have this development. Public Employees for Environmental Responsibility, or PEER, is a group that represents Environmental Protection Agency employees, including whistleblowers. The group filed a lawsuit alleging that President Donald Trump's plan to reclassify workers so that they are easier to fire is illegal. The lawsuit maintains that the plan, quote, exceeds the president's authority under the Civil Service Reform Act, purports to deprive federal employees of property rights without due process required by the Fifth Amendment, and requires federal agencies to violate the Administrative Procedure Act, outlining a reclassification that we've covered previously on this show that is detrimental to all whistleblower protections and the climate of allowing whistleblowers to come forward if they see corruption, abuse, or wrongdoing in their workplace. Finally, we have this headline: the Austrian police detain, threaten British journalist and commentator with prison. Richard Medhurst, who previously was targeted by British authorities and has this cloud of investigation hanging over him, posted a video describing how he was detained. He had his devices. He's working on a book on cybersecurity. It was taken. Let's watch a clip.
Okay. On Monday, agents from the Austrian police and intelligence services detained me, raided my home, raided my studio, and then interrogated me. They essentially lured me into a trap. So I received a letter from the government last week from immigration, summoning me for some interview at my residency. I found that a bit odd because I've lived here for a while. I never had any problems. So having nothing to fear, I went to the meeting by myself. And then After a few simple questions, they suddenly issued a thinly veiled threat saying they were considering revoking my residency because of my alleged reporting on Palestine and Lebanon. So, of course, my answer was no comment. And as soon as I thought everything was over, I was ambushed by a group of plainclothes agents. They entered the room, flashing their badges in my face, and they said that they were the Austrian equivalent of MI5 or the FBI. They detained me, and then they served me with a warrant from the state prosecutor to search my home, search my studio, take all of my devices. Why? Because they think that I, a Christian Englishman, am a member of Hamas. Yes, you heard that correctly. They are accusing me of being a member of Hamas, of being part of the Izz al-Din Qassam brigades, of disseminating propaganda, encouraging terrorism, being affiliated with organized crime and a terrorist group. I mean, it's like reading something out of the Twilight Zone. Then they drove me to my studio and turned the place upside down. So I had to watch my devices being disassembled before my very eyes by a group of strangers. All these tools that I spent years building and investing in, the core of my journalistic profession. They took, in total, they took like 5-6 different laptops and computers, phones, USB sticks, hard drives, DVDs, you name it. And although the warrant was for electronic devices only, for some reason, they took photos of my residence, photos of the office, of the bathroom. They helped themselves to anything they saw: books, papers, documents, cupboards, closets. Now, as you recall, I was unjustly arrested a few months ago in London. They jailed me for almost 24 hours under the Terrorism Act. Strangely enough, last week, the police in England again extended this investigation, and then suddenly this happens in Vienna. I don't think that is mere coincidence.
So you see this alarming escalation involving an attack on freedom of expression. It is growing in the Western world, in particular, as we've tracked it over the last year. We see more and more journalists or advocates who speak up for Palestinians being targeted. They use terrorism laws, or they use laws that are supposed to protect national security, and they are silencing people who are engaged in this journalism or advocacy work. They went after Richard Medhurst in this instance, but we're also seeing pro-Israel groups with ties to the Israeli government that are engaged in their own actions to hit organizations with lawsuits that are vulnerable. We have the nonprofit killer bill, as it has been called, that has moved through Congress last year, likely will be brought up again for a vote in this session of Congress. It aims to remove the tax-exempt status from nonprofits so that these groups can basically intimidate and silence the civil society organizations that are outspoken on the abuses and violations of Palestinian human rights, the attacks on their civil liberties that we see happening systematically, the threats to their existence, the plans for ethnic cleansing that Donald Trump has presented to the world, put his name on. He's looking for real estate development in Gaza. All of that is the backdrop for what we're seeing in this crackdown on freedom of expression. There was a positive development with a judge out in the state of Washington who upheld the First Amendment rights of the Palestine Chronicle, which was targeted by a frivolous lawsuit brought by a former Israeli hostage. That was covered at the Dissenter. I won't go into more details, but I encourage you to go there if you did not get a chance to read that story yet. Now, we have the interview with Chip Gibbons, the policy director for Defending Rights and Dissent. It was good to be able to catch up with him and dig into this case, which, as I say later in the interview, has not received a lot of attention. Joining me now is Chip Gibbons. Chip Gibbons is the policy director for Defending Rights and Dissent. He's also hard at work right now on a book about the FBI, and you may have seen him recently on Democracy Now! Discussing Tulsi Gabbard's confirmation hearing, as well as the confirmation hearing for Kash Patel, who is in line to be the FBI director. Welcome, Chip.
Thank you for having me back, Kevin. It's always a pleasure to be with you.
And he's here to discuss an Espionage Act prosecution. Former CIA analyst Asif Rahman. And to begin here, what does it mean that Asif Rahman pleaded guilty to this Espionage Act charge that he faced?
Well, it's interesting because most Espionage Act cases end in plea deals. Daniel Hale pled, Julian Assange took a plea deal, Terry Albury, reality winner. Very few of these cases ever go to trial. The ones that have gone to trial that I can think of off the top of my head are Dan Ellsberg back in the 70s, Jeffrey Sterling, and Joshua Schulte. So it's very rare for anyone to actually go to trial when charged under the Espionage Act. Rahman has agreed with the government that he is the source of two documents that were published by the Middle East Spectator about a potential strike by Israel on Iran. Israel did strike Iran and Syria and Iraq 9 days later. And what's interesting, and I don't want to get into this now, is that in the statement of facts that accompanied the plea deal, Rahman admitted to the first time for having engaged in other unauthorized disclosures under the Espionage Act. And one of the things about Espionage Act cases is that the government, they're arguing these documents are secret, this information that was released imperiled, national security. So they sort of engage in this secrecy sort of theater, like this pageantry of secrecy. Like, right, the Daniel Hale trial is a great example of this. They had an indictment that listed, all of his appearances of Jeremy Scahill, but they call Jeremy Scahill either reporter 1 or reporter 2. They list the publication that published the documents, clearly The Intercept. They list the days they were published. They list, the subject matter. And yet when I filed a FOIA request, like, oh, we've never confirmed this was what Daniel Hale revealed, even though there's no one else who it could be. In Rahman's case, with the two NGA documents, they sort of engaged in that level of secrecy theater. Everyone knew what it was about. Israel was mentioned by name at the second detention hearing. But with these two new revelations, we really don't know what happened or what's going on. And even the circumstances under which the documents made it to the Middle East Spectator, we don't really understand. Initially, the Middle East Spectator, which is a Telegram and Twitter channel that describes itself as news and analysis, and I believe its Twitter confirms it's based out of Iran, published these documents. They said they're from an exclusive source. They then later said they were on Telegram and another channel, and they had somehow made their way to them, and they had no knowledge of where they came from. We now learned that Rahman in spring of 2024 took home 10 classified documents, classified at the secret and top secret levels, and that he communicated the information in these documents to people not entitled to receive them, and he shared reproductions of them. Then in autumn, before the Middle East Spectator incident, he takes home, I'm sorry, did I say 10 documents before? He took home 10 documents this time. The previous time was 5. He takes home 10 documents, this time top secret, and he, again, communicates information he learned at work to unnamed people, and he gives reproductions of these documents people. We have no idea what they are. I suspect, based off of comments made at one of the detention hearing, they're Middle East related intelligence, but I don't know. And then on October the 17th, the NGA produces these two documents. Rahman prints them, distributes them on the 17th. Documents are created on the 16th. I got the date wrong. And then on the 18th, one of these individuals, who again we know nothing about, but this is from the statement of facts that the defense and prosecution agreed to states that they had confirmed in writing they had further distributed the two documents to other individuals, and this is the day they appear on the Middle East Spectator. So there are, I think we're talking about the disclosure of 17 different documents. We can only identify what 2 of them are. We really don't understand the chain of custody as to how they got to Middle East Spectator. It seems clear that he gave them to some other party who gave them to them. Was this person a journalist? Were they someone in a Telegram channel? I don't know. I will caution people about jumping to conclusions because he's not charged with either under 794, giving national defense information to a foreign government, or another provision under the Espionage Act that makes it a crime for a government employee to give classified information to a foreign agent. It was originally a foreign agent or a communist, Kevin, but now it's just a foreign agent. So he's not been accused of giving information to a foreign government. So I don't think we can. I think we can. So that's not a likely possibility. We can't rule it out completely, but it does not. The government has not alleged it, and I think they would in this case if that's what happened. And then so we don't really know. And then we don't know what these earlier documents were, who they went to. Was it the same people as these 2? So there's a lot of questions. And I'll stop there because I know I've said a lot.
No, yeah, and these are covered in your article for the Dissenter, so thank you for contributing that. And another aspect that you get into is this provision in the agreement where Rahman is agreeing to notify the government if he intends to have contact with somebody who is part of the media. Would you describe why this is concerning? It's kind of self-evident based upon a lot of the topics that I regularly cover, that this show regularly covers, but also generally speaking, this is discouraged anyways by prosecutors and then also the prison staff that he would have to answer to.
So obviously, hello, my cat is joining us. So obviously,
hello, Marcus.
Research assistant, Mr. Marcus. So obviously, there's a lot of restrictions on people in prison. Daniel Hale was put in a communications management unit. I have a strong suspicion Rahman is going there. But this is a provision I've not seen before in a similar case. And it isn't just that he has to notify the government. He has to notify the government if he intends to contact the media. This includes in-person conversations, emails, telephone calls, the mail, so that, and I'm quoting now, representatives of the intelligence community may be present to monitor the information being disseminated and, if necessary, to prevent the unauthorized disclosure of information. It's very common for government employees like Rahman do have to do pre-publication review for written work. I have seen plea deals that include an agreement to engage in pre-publication review. I've seen plea deals that include language about ceasing to disclose information or safeguarding it, but there's never been this sort of prior restraint where you cannot talk to the media unless you have an intelligence officer sitting there in real time, making sure you don't say the wrong thing. I looked through several plea deals. I looked at Julian Assange's plea deal. Okay, he's a journalist. I looked at 2 whistleblowers' plea deals, Reality Winner and Terry Albury, and I even looked at Jack Texeira's plea deal, who is this sort of murky figure in certain ways, and that he's not a traditional whistleblower, he's not a journalist, but he's also not a spy, right? He's someone who put documents in a Discord channel allegedly to impress people online. And even he didn't have this circumstance, or even this provision. I talked to several people, no one had heard of it. I then crowdsourced on Twitter, and somebody did show me a plea agreement that had the same language verbatim. And this was for someone who was accused under 794, which is the espionage provision of the Espionage Act, right? Giving national defense information to a foreign government. And the government in question was China. So the only situation I know of, I can find where this provision is featured is in someone who's pleading guilty to being an actual spy or attempting to be an actual spy. I think it was actually a conspiracy charge. So I even looked at the plea deal. Do you remember the 2 people who were convicted under the Atomic Energy Act recently for trying to give nuclear secrets to a U.S. ally, and they got Bitcoin from the government. And at one point, the government couldn't recover the Bitcoin or whatever. I even looked at their plea deal, and this language isn't in there. So it's very rare. It's not unprecedented, but it is not precedented in similar cases. Why is this here? It is very clear that the government went to great lengths to keep him detained before trial, claiming they thought he would engage in further disclosures. Obviously, the government always says things like that, so who knows? And it could be something specific to Rahman, or it could be someone just copied boilerplate language from another plea deal. There's such a range, we don't know. I can talk about at what stage I think we might get more answers, or unless you want to talk about.
So let me just say on this that I corresponded with former CIA officer John Kiriakou when he was in federal prison. He'd write letters from prison, and I sent him material at least a few times, I believe. And so basically under this provision, if somebody has this, it essentially is putting a restriction on his communications with people while he's in prison, requiring notification. However, what's not clear to me is, wouldn't it all, if he's going to be put in a communications management unit, or if he's going to be under some kind of special administrative, not special administrative measures, that's the wrong term, but have a special security designation, because that was what Kiriakou had while he was at Loretto. That's something they could do without putting him in a CMU. So it just means that he gets extra attention. Then they're already going to be monitoring this. I suppose I'm just trying to figure out why it seems a little redundant, because the prisons already have the capability to impose this absent the prosecutors.
So there's nothing in the language of the plea deal about prison, Kevin, right? This is a permanent a rule. This is right after the right to waive FOIA. So this means that when John does your show, we should actually double check this before you post this, but I'm pretty sure I'm correct. I'm a read of it. John does your show. This means when John comes on this show, an intelligence officer would have to be on the line with you and John. I
think I know what you're saying. So, sorry, I don't want to cut you off, but just to make sure I steer this, the fact would be that after his sentence, he's required to run any invitation to appear on a show by the government. That's basically it. So,
and
like,
the government has to be there in real time.
Right. So this is a provision that's not just, okay, that makes more sense. So it's not just applying to his communications during incarceration, but even post incarceration.
Yes, it's in the same section about foreign government contacts, about FOIA rights, about assignment of profits, about pre-publication review. So as far as I can tell, and maybe my read is wrong, these are forever. So if he was to send a letter to you after he got out of prison, the government would have to read the letter. If he was to meet you at a bar, the government would be sitting at that bar. If he was to come on this program, the government would be on the program with you. Again, you and I have both interviewed people who have been convicted under the Espionage Act. I've interviewed Jeffrey Sterling. I've interviewed John Kiriakou. You've interviewed John, and I think Jeffrey too. You know, any conversation you had with them on the phone, in person, by email, I'm blanking on other types of, by carrier pigeon, perhaps.
I would assume if I was having even if I'm having, like, if he was found to have encrypted chats with me, he would be in trouble as well.
Yes, and it's not just a review; it's a real-time monitoring requirement.
Yeah. All right, so let's jump to, as we wind this down, sentencing, which is on May 15th, 2025, as I previously mentioned in the introduction to our conversation. So there's a potential sentence. Maybe you want to say what you think could be expected. recognizing that the prosecutors are consistently pushing for longer and longer sentences for those who are convicted, but then also your thoughts on this being the first Espionage Act sentencing since Donald Trump's return to the White House.
The sentencing should give us more information about what happened. At this point, people usually start to discuss motives. The government casts the defendant in the worst possible light. Look at what Joshua Schulte, where they argue he sought to harm U.S. national security, or then look at Daniel Hale, where the defense sort of pointed out Daniel Hale's sort of history of conscientious activism and whistleblowing. So what I'm hoping is during the sentencing phase, and several things will happen. You will have a pre-sentencing investigation and report completed by the U.S. Probation Office. You will have responses to that from the prosecution and the defense, and you will have a sentencing hearing at which Rahman could possibly speak. I'm hoping from those things we can learn a little bit more about why he did what he did. Right now, we have no clue what his motivations were. The government argued at one of the hearings they thought he was ideological. They conceded they had no information of that, no evidence of that. They just ruled out other things.
All right. Well, this has received very minimal media attention, and it happened back in January, the guilty plea. And despite the fact that the disclosure received a lot of news media coverage when it happened, because we were in a heightened state of potentially seeing the conflict involve, various countries and including Iran, despite that, we haven't seen that follow through where media organizations give this the attention it deserves. So thanks for putting this together and doing coverage, and thanks for what you do at Defending Rights and Dissent.
Thank you, Kevin.
All right, everyone. Thank you for tuning in to the Dissenter Weekly. If you're a paid subscriber, I'm really grateful to have your support. Thanks for making the Dissenter newsletter possible. If you're just stumbling on the show, watching, tuning in, seeing it for the first time, please share this with others so that they know that we're doing this weekly show. And then take some time for yourself. Take advantage of the weekend. Give yourself a break from the overwhelming torrent that keeps coming from this presidential administration. We've got 4 years, but I hope that during this time, the Dissenter Weekly can develop into a show that you come to when you're looking to sort between the distractions and those stories or those issues that are deserving of your attention.